All right, we're rocking and rolling. We have the Posley separation agreement. I mean, who doesn't? Even co-pilot's all over that one. To me, this smacks of a Von Briesen agreement all over it. So I guess Chris and company did know everything after all. We're going to go through an employment agreement, sort of a golden parachute by a top-level superintendent of one of America's largest school districts here, and we're going to see, how it shapes up and how it plays out. Wisconsin Employment Separation Agreement. Here we go. All right, mutual separation agreement and release of all claims. So far, so good. This separation agreement and release of claims hereinafter referred to as agreement is entered into by and between the Milwaukee Board of School Directors, hereafter Board, and Dr. Keith Posley, here and after Dr. Posley. In consideration of the mutual covenants and consideration here and after set forth, the parties here to agree as follows. Oh my God, this is clearly a Von Briesen one. I would never allow that kind of archaic language in there. Let's translate that. In consideration of mutual agreements and things of value set forth in this document, the parties agree as follows. Bam. Legal writing 101, baby. All right, non-admission. This is very standard here. This is both saying that both parties agree that the other one is not acknowledging liability by signing this agreement. This agreement is made in full, final, and complete compromise and settlement of any disputed claims between the board and Dr. Posley. Neither negotiation, undertaking, agreement to provide, nor actual provision of payments and or benefits under this agreement shall in any way be construed as an acknowledgement or admission by the board or Dr. Posley of any liability or wrongdoing whatsoever. Okay? Now, I just took a contract CLA and I can easily rewrite this that says that this agreement is a complete compromise, possibly, and settlement of any disputed claims between the board and Posley. Nothing in this agreement or the drafting of this agreement is to be construed as an acknowledgement or admission by the board or Dr. Posley of any liability or wrongdoing whatsoever. I guess you could say, additionally, this agreement shall not create any precedent or past practice, but it does, so good luck with that one. This agreement, by the way, is private law between two parties, so this is binding to Dr. Posley and the board and nobody else. Okay. Separation. Now, they must have asked for the short version because it's only a couple of pages. Number thing you have to keep in mind, if we had normally asked for this, if this wasn't a planned release, they would have given this in 8 to 10 years, possibly 2 years. With no doubt, they wouldn't even respond to it in 6 months. So just like the DPI letter that came out, there is a letter from the state of Wisconsin saying that Dr. Posley here committed malpractice by not reporting certain numbers. We know that they would never ordinarily do that. It's my experience. That's what they told me. All right. Dr. Posley hereby acknowledges his irrevocable resignation from the employment with the board effective June 30th of 2024. The board hereby accepts his resignation. In the event now, normally what's supposed to happen is there is a public hearing or the ability for there to be a public hearing, and that his original contract will say that it cannot be modified except by both of the parties in writing. So that's what's happening here. The board accepts his resignation. In the event, which as we all know, that he will, retires within the Wisconsin retirement system because he's not going to get a job as a superintendent in Wisconsin ever again. As of June 30th of 2024, he remains eligible if he otherwise qualifies for the district post-employee district post-employee retiree health benefit. One wonders if Deb Keithra got that. Just for example, one wonders. Severance payment. The board agrees that certain pay and benefits shall be payable to Dr. Posley due to the separation without need for consideration. That means he's got things in his contract that are ongoing, vacation pay, allowances, all those kind of things that he is entitled to for no reason at all. Even if he just leaves, he's supposed to get all those things. So they've got to give him something additional. Okay? So therefore, it's saying, regardless of whether or not Posley elects to sign and not revoke this agreement, I'm going to read that again. Therefore, regardless of whether or not, we'll just say whether Posley elects to sign and not revoke this agreement, the board shall pay Posley the following on the first pay date following the date of separation. Whoa. Of course, I don't have my finger on the cough button. Okay. I'm confused here because it's legalese, so let's get clear. The board agrees that certain pay and benefits shall be payable to Dr. Posley due to this separation without need for consideration. Therefore, regardless of whether or not Dr. Posley elects to sign and not revoke this agreement, he should have the ability to revoke it, but let's see if that's in there. The board shall pay Dr. Posley the following on the first pay date following the date of separation set forth herein. All pay earned and not paid through the date of retirement. All accrued and unused vacation and personal pay. I'm not sure what all paid earned and not paid through the date of retirement means. Because he's not retiring, he's separating, he's resigning. So there's no... Somebody didn't read this very carefully. Okay. Upon execution and non-revocation of this agreement, Dr. Posley shall be paid a severance payment in the amount of $160,000 payable in a lump sum amount minus appropriate taxes. Okay, so they're giving him $160,000 for leaving. Upon execution and non-revocation of this agreement, effective July 1st of 2024, Posley shall be eligible for COBRA, and the board shall pay the first 6 months. So it's really $160,000 plus 6 months of health care, which is substantial. Posley, or until thereafter, the extent, yeah, okay. Execution and non-revocation, the board shall pay $38,000 into the school director's 403B plan with such payment to be made. So it's $200,000. That's what it is. It's $200,000. Acceptance procedure. The board wishes to ensure that Posley volunteered to agree to the terms contained in this agreement and shall do so only after they are fully understood by him. Accordingly, the following procedure shall apply. Posley shall have 21 days from the date he receives to consider the agreement. If signed, he'll have 7 days for withdrawal. They have to do that because he's over 40. The board encourages Posley to review this document with an attorney of his choice prior to signing it, which may or may not happen. The document constitutes a complete understanding between the board and Dr. Posley, considers all matters addressed herein. If Dr. Posley accepts this agreement, it shall supersede all prior agreements, understanding, and practices concerning such matters, including but not limited to any contracts, personnel documents, handbooks, or policies, and any prior customs or practices of the board. This document shall be governed by the state of Wisconsin. That's a pretty important thing to put in there. The provisions of this agreement are severable, and according to any provision is held by any court or agency of competent jurisdiction to be unenforceable for whatever reason. The remaining provisions herein shall continue to bind the parties and be fully enforceable. It is specifically agreed that in the event of any pending or future legal proceeding which is waived and or released by this agreement shall serve as a full and complete defense. Okay, so that means he can't sue them for anything. Waiver. Dr. Posley, on behalf of himself, his heirs, assigns, hereby irrevocably and unconditionally releases and discharges the board, Milwaukee Public School directors, the respective agent officers, yada, 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 for any and all grievances, claims, demands, rights, damages, costs, losses, suits, actions, cause of action, attorney's fees, and expenses of any nature. Okay. Unforeseen, foreseen on the board, whether or not statutory, other wrongdoing. This is, and libel, let's say, including any tort, claimful, negligent infliction of emotional harm, libel, slander, invasion of privacy. Wow. All right. This agreement excludes, does not release or discharge claims which cannot be released by law. Good. They got that in there. Meaning he can still file a bar complaint against somebody or file for unemployment. Any matters that arise after the date of this agreement. Posley affirms that he's not filed or caused to be filed and is presently not a party to any claim, complaint, or action against the board in any forum. I don't think that's accurate. I don't think that's accurate. I don't see how we can affirm that based on a simple Pacer reading. Dr. Posley affirms that he has not filed or caused to be filed and is presently not a party to, let's just say it was Dr. Keither versus Dr. Posley and the various Milwaukee school, MPS, and et cetera. I don't know how he could claim that. Dr. Posley that he has no known workplace injury or occupational disease, and he has provided with or denied any leave requested under state or family or medical leave provisions. No further claims. In further consideration, Dr. Posley agrees not to file. This is for the board, right? So this is working. They're paying him $200,000. He's agreeing not to sue them. In further consideration, Dr. Posley agrees not to file any action, claim, grievance, request for hearing, or other such matters against the board, including but not limited to the board's agents, officers, et cetera, et cetera, et cetera. Okay. Non-disparagement. Dr. Posley agrees not to disparage the board, Milwaukee Public Schools, or its respective agents. Well, that's not clear. Is it the board's agents or Milwaukee Public Schools agents or what? Officers, members, representatives, or employees, whether past or present, regarding any matter related to, arising out of, or in any way connected with Dr. Posley's employment by the board. The board agrees not to disparage Dr. Posley. I would like a definition of what the heck disparage means, but who knows? All right. Dr. Posley agrees to fully cooperate with the district with any litigation following the date of this document. So hopefully he'll be available because of that. So that's great. Reemployment. This is something that has broken many agreements. Dr. Posley understands that as a condition of this agreement, he shall not now be entitled to or hereafter to any employment, or reemployment with the board, and further agrees not to institute any action, lawsuit, or proceeding against the board for any failure to employ or reemploy him. Okay? Dr. Posley understands that he has no right to return and that MPS may or may not hire him at its sole discretion. And Posley agrees to hold the board harmless for not hiring him in the future. Simple. Interpretation. The parties acknowledge that this agreement shall not be construed against either party on the grounds of sole authorship. That this isn't. Normally, there is a rule that says that the complaint goes against the drafter. If there's an ambiguity, it goes against the person who wrote the thing. Okay, because you had the opportunity to make it clear and you didn't. Here, this is saying because Posley had opportunity to work on this document, or at least that they agree that just because one party wrote it doesn't mean that it'll go against the other one. Okay. Voluntary agreement. Dr. Posley acknowledges that he has read all the terms of this agreement, understand the terms of this agreement, including the fact that he has agreed to permanently and irrevocably sever his employment. Well, it's not quite true. That's inaccurate because he's got a 21-day plus 7-day waiting period, so no. Neither the board or its agents, representatives, employees have made any representations to Posley concerning the terms of effects of this agreement other than those contained in this agreement. Dr. Posley signs this agreement voluntarily and of his own free will in exchange for consideration to be given to him, which he acknowledges is adequate and satisfactory. Well, there you go. That is the resignation of Keith Posley. There's no document on there. I'd like to see the metadata on the original one, that's for sure. But in my mind, this looks like the Von Briesen law firm, that is Chris Reardon, who represents MPS, wrote this. And yeah, there we have it, a complete separation agreement. A document unlike many I've ever seen before, in that its simplicity and the fact that it was made public without any fight whatsoever. It's almost as if they wanted the public to know. Do you think $200,000 is an adequate price to get rid of Keith Posley? Do you think they could have just simply fired him for cause? You tell me. Bam. But how can you tell me if I don't hit the stick with us, we'll keep you informed in outro music? That would be almost unbearable. Take care, everybody.